The chair recognizes the gentleman from Texas, Mr. Poe, for 5 minutes.
Thank you, Chairman. Thank you, Mr. Ray, for being here. My background, I was a former prosecutor. I was a judge for 22 years. During that time in the criminal courts, I had always thought that the FBI had a stellar reputation. In the last few years here in Congress, I don't have that belief any longer. Your predecessor did a lot to damage the reputation of the FBI. I don't think that the FBI has come back around with that stellar reputation, and that's unfortunate. You gave us lots of statistics in the opening statement that you made about what the FBI is doing. I want to talk about FISA, secret courts issuing secret warrants, supposedly to go after terrorists overseas. A recent our Washington Post article made the comment or stated that when information is seized on bad guys, there's the so-called seizure of information that belongs to Americans, inadvertent as it's called by the legal community. And in that database are Americans and non-Americans. In the Washington Post article, quote, says many of them in this database were Americans. 90% of the account holders whose communications were collected under 702 were not the intended targets. And about half of the surveillance files were on Americans. So you have this database that's supposed to go after the bad guys, and you get that information, but inadvertently you pick up all of this information on Americans who have nothing to do with terrorism. How many times has this database been queried, I call the word searched, to find out if there are identifiers on Americans? How many times has the FBI or the intelligence agency or government done that?
Congressman, I don't have numbers for you here today. I will tell you that the database that we're talking about is not bulk collection on anyone, first. Number two, it is a database of foreigners reasonably believed to be located overseas for foreign intelligence purposes. That's what's collected by the NSA.
I may interrupt you. FBI, reclaiming my time. But I'm talking about the inadvertent seizure of information based on this idea we're going after terrorists. How many people have been queried, searched in that big database? That's my question.
And Congressman, I don't have the statistics for you. I can give you one number that may be helpful to you in answering your question, which is that of what the NSA collects, that the FBI only receives, much less queries against, about 4.3% of what the NSA collects. And the individuals that are incidentally collected, the U.S. person information that's incidentally collected, are people who are in communication with foreigners who are the subject of foreign intelligence investigation. So like an ISIS recruiter, if there's a U.S. person picked up, that person would have been in email contact, for example, with an ISIS recruiter.
Understand that. I'm not talking about terrorism. I'm talking about the inadvertent where there's a communication with an American, and that American's information is seized and then later searched by whether it's the intelligence community or the FBI. The Washington Post said 90% of those seizures were on non-terrorists. Do you agree or disagree with that statistic?
I haven't reviewed the Washington Post article.
This committee has asked for a long time to give us that information because we are now coming up with FISA reauthorization. My opinion is that the FBI and the intelligence service is backwalking that information because they know FISA comes up at the end of this year and then Congress would just reauthorize it without knowing how many Americans are searched. The right of privacy in the Fourth Amendment is guaranteed. I'm sure you believe this. But it is being abused and stolen by government in this situation on what's happening to Americans. And the search of that database, whether it's the first query, which is a search, or a later specific search of that communication, is being done in secret by our government. And Congress, Judiciary Committee, is entitled to that information. And I will disagree with what you said about, well, it's classified. I can't tell you that. you that. That's ridiculous. Congress is entitled, members of Congress are entitled to every classified piece of information that is in your possession. That is our position. That is our right as members of Congress. So government can't have classified information and say, we're not going to tell you because it's classified. We're entitled to it in some type of setting. So I totally disagree with you on that. I hope you can provide us that information before we reauthorize FISA. Otherwise, I'm going to vote against FISA. And I'll yield back to the chairman.
Mr. Chairman, may I briefly respond?
The director may respond.
First off, as to classified information, we are engaged with the intelligence committees, and we share classified information with the intelligence committees all the time. And then under certain circumstances, as the chairman noted, we are also sharing classified information with the authorizing committees, like the two judiciary committees. As to the question of abuses, every court to have looked at the way in which Section 702 is handled, including the querying, has concluded that it's being done consistent with the Fourth Amendment, as has the Independent Privacy and Civil Liberties Oversight Board. And there has been no abuse found in the 702 program despite oversight by the Inspector General, multiple sections of oversight within the executive branch, oversight by the federal FISA court, and oversight by the intelligence communities.
And I disagree with the secret courts on their interpretation of the Fourth Amendment, as does many other members of Congress. Thank you, Mr. Chairman.
Chair, thanks, gentlemen. His time has expired. I just want to reiterate, as with the other request, this is a reasonable request by the gentleman from Texas. It has been made in varying forms by this committee in a bipartisan way in the past, and we have not yet received the answers to those questions. So I would again point out that this committee has oversight responsibility of both the Foreign Intelligence Surveillance Court and the Federal Bureau of Investigation, and we have a very nice SCIF where this all can be discussed in a classified setting, where documents can be examined in a classified setting, and we think that you need to be forthcoming on this. So thank you, Director. The chair recognizes the gentleman from Florida, Mr. Deutsch, for 5 minutes.
Thank you, Mr. Chairman. Director Wray, thank you for being here today, and thank you for your service to our country. Director Wray, as you know, what separates the United States from the oligarchies and despots around the world is the American commitment to the rule of law. That means that powerful people don't get to write their own rules. It means that the president doesn't direct law enforcement to target political enemies or to go easy on political friends. And it means that judges, police officers, and the FBI agents are not intimidated by demands or tweets or whispers coming out of the White House. Director Wray, I want to commend your commitment to the independence of the FBI and to the rule of law. As to the president's tweet over the weekend that the reputation of the FBI is in tatters, the worst in history, which sadly seems to be shared by many of my colleagues on this committee, I would like to just take a moment to thank the women and men of the FBI for their hard work, for the work they do investigating threats of terrorism, public corruption, organized crime, cybercrime, white-collar crime. I'd like to thank you and them for the work they do to combat violent crime, and I'd like to thank you for the work they do to enforce our civil rights laws. I also want to thank your agents that are working with the Mueller investigation, an inquiry that has already delivered serious charges against the president's campaign manager and a guilty plea from the president's national security advisor. Back in September, you reviewed the classified reports compiled by the U.S. intelligence agencies that concluded that Russia interfered in the 2016 election and tried to tilt it in Donald Trump's favor. You said at the time, I have no reason to doubt the conclusions that the hardworking people who put that together came to. You still have that view?
I still believe fundamentally that the conclusions of the ICA are accurate.
And the FBI continues to focus on the threats posed by Russian interference in future elections?
Yes, as I was mentioning earlier, we are, special counsel, of course, is looking backwards. We're looking forward. We're focused on trying to make sure that any effort by any foreign power to interfere with our elections is something that we can try to get in front of, investigate, and prevent as best we can.
When the special counsel looks backwards on what happens, it's important the special counsel be able to do his job. there is legislation, bipartisan legislation that's been introduced that, as I understand it, codifies existing DOJ regulations that a special counsel may only be removed for misconduct, dereliction of duty, incapacity, conflict of interest, or other good cause. Is that how you understand the DOJ regulations?
I'm not intimately familiar with the exact wording of the regulations, but I have no reason to doubt your summary of them.
Which is why, Mr. Chairman, we ought to be doing exactly that. We have sat here for almost 2 hours and have heard nary a word from my Republican colleagues about Russian interference in our election or about the efforts of the Mueller investigation to get to the bottom of it. And based on the talking points that we've heard that sound so eerily familiar to those coming from the President of the United States, it is more apparent than ever that this bipartisan legislation to protect the special counsel, to ensure that the special counsel can do his job and can pursue ultimately the truth wherever it takes him, has to be brought up in this committee. Must be. I would urge my colleagues who are as concerned about the Russian interference in our last election and the potential Russian interference in future elections, who are as concerned as Director Wray and the FBI, and so many of us are, to let us protect the special counsel. Director Wray, you also said in September, and I quote, that you said that you saw no evidence of White House interference in the probe, the Mueller probe, and you said, quote, I can say very confidently that I have not detected any whiff of interference with that investigation, close quote. I want to make sure that that continues to be your position.
Certainly, Congressman, as I sit here today, I am not aware of, since I've been on the job, there's been no effort that I've seen going forward here, any effort to interfere with Special Counsel Mueller's investigation.
Director Wray, if the President of the United States fired Special Counsel Mueller, would that constitute interference with Special Counsel Mueller's investigation?
I'm not going to engage in a discussion of hypotheticals. It would obviously depend on the circumstances surrounding the firing.
If the President fired the special counsel without satisfying any of the requirements that currently are in DOJ regulations, without doing it for cause, but only because he was concerned about the special counsel getting too close to him or his closest advisors or his family, I think the answer to that is clear to anyone who is watching today. And that's exactly why at this moment, Mr. Chairman, we have to protect the special counsel. There is legislation to do it. History is being written at this moment, and what it's seeing is efforts to obscure the very reality that's taking place in this country, which is the President's efforts to try to avoid the special counsel getting too close to him. We can do something about that to protect this investigation on behalf of the American people, and I do hope that we will, and I yield back.
Time, the gentleman has expired. The chair recognizes the